Florida Insurance Guarantee Association.
May it please the court, Brian Growdy of Creedy and Growdy on behalf of the petitioners. With me at counsel's table is my co-counsel, Ron Hobgood. Today, this court must decide whether the following type of claim is a covered claim that FIGA must pay. An insured's claim for section 627.428 fees incurred by an insured in a suit against its now insolvent insurer that before the insolvency confessed judgment on the underlying loss claim. A covered claim is one that must arise out of and be within the coverage of the insurance policy. That's what section 631.54 sub 3 states. The type of fee claim that we are here today on is a covered claim because section 627.428 is a part of every insurance policy in Florida, and it obligates every insurer to cover the fees incurred by its insured in successfully prosecuting a suit against the insurer.
Mr. Growdy,
Yes.
why doesn't section 631.70 control the outcome of this case?
Section 631.70 provides a separate analysis for post-insolvency fees distinct from the analysis under section 631.54, which deals with covered claims.
Where does it say post-insolvency?
Well, I'm going to point you to the plain language. I'm going to point you, and then I'm going to point you to some history. First, you're right. It doesn't say post-insolvency, but what 631.70 says is that 627.428 shall not be applicable to any claim presented to FIGA. Let's stop there. They conceded in the trial court, FIGA conceded in the trial court that the underlying loss claims were never presented to it. Page 19 and 20 of the summary judgment hearing transcript. The underlying loss claim was never presented to FIGA. The only claim that has been presented to FIGA is the fee claim under 627.428. And that was the facts in Soto as well from the third DCA. The fee claim, the underlying loss claim, both here and in Soto, were fully paid before the insolvency. So the only claim that's ever been presented to FIGA is the 627.428 fee. So let's continue on with the plain language. Except when FIGA denies by affirmative action a covered claim. And here we're contending that the fee claim is a covered claim under 631.543, and then FIGA's clearly denied it, as we're here before the Supreme Court now arguing over whether it's a covered claim, as well as by other proceedings below. So, 631 does not, I'm sorry.
I'm sorry. I'll let you finish.
631.70 doesn't apply under the plain language, and I'm happy to go into some history, but...
Well, this all turns on whether this claim for attorney's fees is a covered claim.
I agree.
I mean, that's not really oversimplifying it. There are different angles to approach it from, and you've got these various statutes that interact, and I think you've done a very nice job in your brief of making your case. But let me ask you this. Don't you have a problem with the concept of covered claim in this context? Because that points us to a meaning that's not related to attorney's fees, but related to a claim that is against an insurable loss, something that's covered in the sense that insurance provides coverage for losses. And that kind of ordinary understanding of the term of coverage and covered claim is really at cross purposes with your argument.
I agree it's at cross purposes with the ordinary and probably typical thing when you think of coverage. But let's go back to 631.54 sub 3. The only example that it gives of a covered claim is an unearned premium.
But is that really an example? I mean, I think that's a good argument. But that is so different than covered claim. And when I read that, I almost think they're talking about covered claims and they say, and we're going to add this, even though it's not really something that you would think of as a covered claim, but it's kind of a tack on.
But that's not what the language says. It doesn't say and. It says a covered claim means an unpaid claim, comma, including one for unearned premium, comma, which arises out of and is within the coverage of the policy. And so therefore, the which clause modifies both covered claim and modifies the general term unpaid claim and the specific example unearned premium. And just to show you how it is analogous to attorney's fees, both cover a risk that's controlled, a risk of an occurrence controlled by the insurer. For an unearned premium, it typically is going to happen when the insurer decides to cancel the policy. And let's say an insurer 30 days before insolvency, 15 days before insolvency, cancels the policy and fails to return the premium. I have a claim for an unpaid, for the unearned premium. I can get it from FIGA. Did FIGA do anything wrong? No. But clearly under the statute, I'm allowed.
But again, I guess, and it really is, to me, and I'm sort of going along with what Justice Kennedy said, unearned premiums don't arise out of and is within the coverage in a typical sense. So my thought is that they were including this unearned premiums because that would not be otherwise a definition of a covered claim that arises out of the coverage. The alternative argument is to say they could have just as easily said, including one of unearned premiums and previously incurred attorney's fees under 627.428.
Well, they could have listed all the examples, and if you.
What other example? But let's go over it. What else other than? What would you agree could not be under covered claim? What would be? Give me another example.
I would tell you a negligence or a fraud claim where you're trying to get a return of a premium would not be a covered claim. But if the statute says that an insurance company, when it cancels the policy, must return the premium, that would be a covered claim.
Well, but
unearned premiums can be. I'm sorry to interrupt. Unearned premiums and fees can be on both sides. You have to do the analysis and ask whether it's within the coverage and arises out of the policy.
But part of your argument is that this is covered because it's implied by law to be part of rights that are that the policyholder has.
Correct.
Well, wouldn't that apply to the claim for negligence that you were referring
No, that would
to?
be a general tort claim. It's not based on.
But it's something that the policyholder has. Still be part of what the law provides as a right.
Well, the case law that we cite does not say that general tort claims like fraud or generally applicable protection statutes that are outside of the insurance context are incorporated into the insurance policy.
You would have 624.155 would also go in. That's a statute.
Well, I think that would be a much closer question, because if you go back and you trace the history of bad faith, and you even mentioned this in the court mentions this in the Jones opinion, those have often been considered non-contractual damages. And I think that
But it's a statute. It is. Your argument is that it's part of every contract, and 624.155 is part of every contract now.
I don't think this court has ever. I'm unaware of any decision that this court or even a DCA has held that 624.155 is a part of every contract. Now, 627.428 is under Chapter 627, which is titled the insurance contract. And,
Well, I can
and
see
this
your
court
argument.
has.
I could see your argument if you had defended the insured, and the contract, we know liability policies cover both defense and payment.
Right.
They provide, and if that had been done, those attorney's fees can be, I think, legitimately argued. Would you not agree, as part of a covered claim under the policy?
Correct, I would
But now
agree. Now,
you're
the
on
second would not, under its all the way decision, I think.
But again,
I
you're
would
in a
agree
different
with you.
category. You're in a different category. You're under first-party benefits under the contract.
Correct, and it's a statute that's under 627, which is titled the insurance contract, that this court has repeatedly held is a part of every insurance contract in Florida, has repeatedly held for 75 years. And therefore, because it is part of the insurance contract, it covers a risk that is triggered when the insurer refuses to pay. And so therefore, it arises out of and is within the coverage of the policy. I think I understand your questions about 624.155. I have looked at that some. I think that's a whole nother case. I don't think necessarily it follows that just because you ruled today that 627.428 would give rise to a covered claim that's a bad faith claim under 624.155.
I would agree with your argument to a certain extent that attorney's fees under the example that I suggested to you is in the nature of a covered claim, because the policy promises to defend you and promises to pay the claim. Liability situation. Not the same with the first party benefit like we're involved with here.
But if the let's say the policy expressly cut and paste 627.428 out of the statute and put it in the policy, that we're now putting form over substance. I mean, every policy by Florida law includes that provision, whether or not it's expressly in the policy. And there's lots of other examples where even if the insurance policy does not expressly say something, for example, it has the incorrect amount of coverage that's required by law, that's going to be incorporated into the policy because of the heavily regulated nature of insurance contracts. So I think the lack of the express provision. You're agreeing with me, Justice Lewis, that the liability provision, it would be covered. Well, wouldn't it be just silly to say, well, if the insurer had written 627.428 into the policy, it would be covered then? I don't understand.
I can see interpreting the statute to that extent where there's a duty to defend. But I do. I mean, it's interesting, the limits. I mean, there are others that. I hear what you're saying.
Yes,
Your argument that attorney's fees are implied in every contract, that derives from State Farm versus Palma. Is that correct?
Well, actually, it goes back 75 years.
But in Palma,
Palma's, I think, the most famous case, but
did
it's
that not
actually in a lot of
involve
cases.
some kind of radiology of something that the attorney wanted, he had to seek payment for and sought attorney's fees for that?
I think the precise issue in Palma was whether or not you could get fees for time spent litigating fees. And the court concluded you could for entitlement to fees. And the only way the court could reach that conclusion was to hold that 627.428 was part of the policy, because if you go to 627.428 itself, it makes it clear you can only get fees for things that are under a policy, with the exact words, under a policy. So for you to hold here differently would be inconsistent with Palma, because if it's not part of the policy, then Palma's wrong, because you can't get fees for anything that's you've spent litigating that's outside of the policy. So you're not going to be able to reconcile their two decisions if you disagree with us. The other reasons, just real briefly, I wanted to get back to Justice Polston's question, which is if you go back and look at the Zinksmith case, which FIGA has conceded was the genesis for the 1977 amendment to 631.70, that was only involved post-insolvency fees.
Let's talk about the plain language again for a moment.
Okay.
Your whole argument is that the attorney's fees under 627.428 are part of the covered claim in this case.
It's part of the insurance policy, and therefore it is a covered claim. We have 2 covered claims in this case.
All right, well, if it's part of the claim, you're still talking about that it's included in the claim to FIGA. So what you're really arguing, it seems, is that attorney's fees under 627.428 is part of the claim now being presented to FIGA, which 631.70 clearly prohibits.
I guess I have to correct your premise, which is you keep saying a claim presented to FIGA. You can imagine an insurance policy, you have multiple coverages, one for one for liability, and you could have multiple claims under the same policy. The law has always recognized that. You can have multiple claims out of a judgment.
One of which you're trying to make one for attorney's fees.
Right, but you keep saying that it's part of the claim. It's part of the fee. It's part of the fee claim. Yes, I mean the fee claim was presented to FIGA. The loss claim was not. So the fee claim was presented to FIGA and denied, and therefore the 631.70 doesn't protect FIGA.
Does the procedural setting in this case make a difference with regard to, in your case, you already have, the judgment was already entered, correct?
That's critical. I think if there was a confession of judgment, which under this court's case law is
tantamount to a judgment.
If there had not been a judgment, we would probably be, I would concede, we would not be able to get our fees in this case.
Well, did you say, was there any different, and I was going to sort of follow up, does it matter, there was a motion for an award of attorney's fees, but there was not a judgment entered for attorney's fees or a determination of amount?
There was not, but under this court's, Wallard and other cases, this court has held that once the insurer pays, that's a tantamount to a judgment.
But the amount was not determined?
Well, the amount of the loss claim was.
The amount of attorney's fees?
No, but.
So now, let's go one step further. Now you say you're entitled, say, to $50,000. It's presented to FIGA, and they say, well, we'll give you attorney's fees, but we think looking at this, you're only entitled to $10,000. That's litigated. Do you get fees in determining how much is the amount of the fee?
No, not under Palma. You only get.
No, also not only under the language, you can't get it against FIGA.
If FIGA admits that they have to pay the fees, like
something.
If when it was presented and they said, "Yep, we have to pay," and then we just spend time litigating the amount of fees, I would